Legislative Department. Legislative Power. Scope and limitation of legislative power. Legislative power is the authority to make laws and to alter and repeal them. Who may exercise legislative power? The Congress. Legislative power shall be vested in a Congress, which consists of a Senate and a House of Representatives. Section 1, Article 6. Grant of legislative power to Congress is plenary. Congress may legislate on any subject matter provided that constitutional limitations are observed. Regional or local legislative power. A regional assembly exists for ARMM, the exercise of legislative powers by local government. Requirements for a valid ordinance. CUPPU-GC. CUPPU-GC. A. It must not contravene the Constitution or any statute. B. It must not be unfair or oppressive. C. It must not be partial or discriminatory. D. It must not prohibit but may regulate trade. E. It must not be unreasonable. And F. It must be general and consistent with public policy. From the case Matas versus Price Properties, 1994. People's Initiative on Statutes. Legislative power is also vested in the people by the system of initiative and referendum. Section 1, Article 6. The power of initiative and referendum is the power of the people directly to propose and enact laws or approve or reject any law or act or part thereof passed by the Congress or legislative body. Section 32, Article 6. The provision is not self-executing. From the case of Defensor Santiago v. Comelec, 1997. RA 6735, an act providing for a system of initiative and referendum and appropriating funds thereof, is valid for A. Laws, B. Ordinances, and C. Resolutions, but not amendments to the Constitution. From the same case, Defensor Santiago v. Comelec. Congress may delegate legislative powers to the Congress in times of war or in other national emergencies. David v. Macapagal Arroyo, 2006. The President, under martial law or in a revolutionary government. Section 23, Article 6. In times of war or other national emergency, the Congress may, by law, authorize the President, for a limited period and subject to such restrictions as may be prescribed, to exercise powers necessary and proper to carry out a declared national policy, unless sooner withdrawn by the Constitution or the Congress. Such power shall cease upon the next adjournment thereof. Congress may delegate legislative powers to the President in times of war or in other national emergencies. From the case David v. Macapagal Arroyo, 2006. Principle of non-delegability and its exceptions. What is the principle of non-delegability? Principle delegata potestas non potest delegare. What has been delegated cannot be further delegated. Rationale. Since the powers of the government has been delegated to them by the people who possess the original sovereignty, these powers cannot be further delegated by different government departments to some other branch or instrumentality of the government. General rule is only the Congress as a body may exercise legislative power. The exceptions are 1. It can be delegated or delegated legislative power to local governments. 2. Constitutionally granted or grafted. Exceptions. 1. First example is emergency power delegated to the executive during the state of war or national emergency. Section 23, Paragraph 2, Article 6. 2. Certain taxing powers of the President. Section 28, Subsection 2, Article 6. 3. The extent reserved to the people by the provision on initiative and referendum. Section 1, Article 6. Take note. Subordinate legislation made by administrative agencies, the principle of non-delegability should not be confused with the delegated rule-making authority of the implementing agencies. Strictly speaking, what is delegated is not law-making power, but the rule-making power limited to A. filling up the details of the law, and B. ascertain facts to bring the law into actual operation. Traditional or simplified formulation. Whom may exercise legislative powers? Generally, it's only the Congress. But the exceptions are plate, Plate. 1. Delegation to the people by initiative and referendum. 2. Delegation to the local governments. 3. Delegation to administrative bodies. 4. Delegation to tariff powers to the President under the Constitution. 5. Delegation of emergency powers to the President under the Constitution. The President did not proclaim a national emergency, only a state of emergency in the 3 releases in ARMM. She did not act pursuant to any law enacted by Congress that authorized her to exercise extraordinary powers. The calling out of the armed forces to prevent or suppress lawless violence in such places is a power that the Constitution directly vests in the President. She did not need congressional authority to exercise the same. Ampatuan versus Puno, 2011. Under its plenary legislative powers, Congress can delegate to local legislative bodies the power to create local government units subject to reasonable standards and provided no conflict arises with any provision of the Constitution in the case of SEMA versus Comelec, 2008. Test for valid delegation. Rule. There is valid delegation of legislative power when it follows the following test: the completeness test and the sufficient standard test. What is a completeness test? The law sets forth the policy to be executed, carried out, or completed by the delegate. From the case of Abacada, such that there is nothing left for the delegate to do but to enforce the law. Case of Pelais versus Auditor General, 1965. And sufficient standard test. The standard defines legislative policy, marks its limits, maps out its boundaries, and specifies the public agency to apply it. It indicates the circumstances under which the legislative command is to be effected. The case of Edu versus Ericta, 1970. Note: acts which are purely legislative in character, such as making of laws, cannot be delegated to administrative bodies, in contrast to the ascertainment of facts or the filling of details, which can be delegated to administrative bodies. Chambers of Congress, composition and qualification. Senate versus House of Representatives. So what are the composition and qualification of Senate and the House of Representatives? Such is provided for Senate in sections 2 to 14 of Article 6, for House of Representatives, sections 5 to 8 of Article 6. Composition of the Senate, 24 senators elected at large. Composition of House of Representatives, not more than 250 members unless otherwise provided by law, consisting of A. District representatives and B. Party-list representatives. Composition, qualifications of Senate: A. Natural-born citizen. B. At least 35 years old on the day of the election. C. Able to read and write. D. A registered voter. E. Resident of the Philippines for at least 2 years immediately preceding the election. Qualifications for House of Representatives: A. A natural-born citizen. B. At least 25 years old on the day of the election. C. Able to read and write. D. A registered voter in the district he seeks to represent. E. A resident of the said district for at least 1 year immediately preceding the day of the election. Term of office of a Senate, 6 years. Term of office of House of Rep, 3 years. Term limits: for Senate, 2 consecutive terms. For House of Representatives, 3 consecutive terms. In the case of Prevaldo versus Comelec, citizenship must be Filipino at the time of the assumption of office. Prevaldo versus Comelec, 1996. Residence requirement. Residence refers to the physical presence of a person in a given area, community, or country. How is it different from domicile? Domicile is a place of habitual residence, where a man must have domicile somewhere. 2. Once established, it remains until a new one is acquired. And 3. A man can have but one residence or domicile at a time. Acquisition of domicile. It can be by 1. Bodily presence, 2. Animus maninde, or intent to stay, and 3. Animus non revertinde, or no intent to return. Requisites to change domicile. 1. Actual change of domicile. 2. Bona fide intention of abandoning the former place of origin and establishing a new one. 3. Acts which correspond with the purpose. Residence for election purposes is used synonymously with domicile. Senate. The Senate of each Congress acts separately and independently of the Senate of the Congress before it. Due to the termination of the business of the Senate during the expiration of one Congress, all pending matters and proceedings such as unpassed bills and even legislative investigations of the Senate are considered terminated upon the expiration of the Congress, and it is merely optional of the Senate of the succeeding Congress to take up such unfinished matters, not in the same status but as if presented for the first time. From the case of Balag versus Senate of the Philippines, 2018. House of Representatives. A. District representatives and questions of appointment. Who are district representatives? They are elected from the legislative districts apportioned among the provinces, cities, and Metro Manila area. What are the rules on apportionment of legislative districts? 1. Apportionment of legislative districts must be by law, which could be A. 1. A. General appropriation law, or B. A special law, that is creation of new provinces. A general apportionment law or special law. Take note, the power to apportion legislative districts is textually committed to Congress by the Constitution, thus it cannot be validly delegated to ARMM, Regional Assembly. Case of SEMA versus COMELEC, under the Constitution and the LGC, apportionment and reapportionment do not require a plebiscite. From the case of Bagabuyo versus COMELEC, 2008. Another rule on the apportionment of legislative district is proportional representation based on number of inhabitants, where A. Each city with a population of at least 250 shall have at least one representative, and B. Each province, irrespective of the number of inhabitants, shall have at least one representative. So, ang 250 applies only to cities. Ang province, walay number of inhabitants ang need, but they are entitled to one representative. Third rule on apportionment by legislative districts. Each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory. Take note, anti-gerrymandering provisions. Fourth rule on apportionment is the reapportionment by Congress within 3 years after the return of each census. Apportionment refers to the termination of the number of representatives which a state, county, or other subdivision may send to a legislative body, Apportionment refers to the determination of the number of representatives which a state, county, or other subdivision may send to a legislative body, while reapportionment refers to the realignment or change in legislative districts brought about by changes in population and mandated by the constitutional requirement of equality of representation. Bagabuyo versus COMELEC. So we're done with district representatives and question of reapportionment and rules of reapportionment. Let's go to party list system. Sa maning party list system, party list representatives shall constitute 20% of the total number of representatives elected through a party list system of registered national, regional, and sectoral parties or organizations. What are sectoral representatives? For 3 consecutive terms from February 2, 1987, one-half of the party list seats shall be allotted to sectoral representatives to be chosen by the apportionment, should be chosen by appointment or election as may be provided by law. Until a law is passed, they are appointed by the President from a list of nominees by the representative sectors. Section 7, Article 18. Note that the party list system is not synonymous with sectoral representation. From the case of Atong Paglaom versus Comelec, citing the 1986 Constitutional Commission records. What are the guidelines from Atong Paglaom on party list system? Party list system. 1. 3 different parties or organizations may participate in the party list system. It could be A. National, B. Regional, or C. Sectoral. Second rule. National and regional parties or organizations do not need to A. Organize along sectoral lines, or B. Represent any marginalized or unrepresented sector. Third rule. Political parties may participate in the party list system provided A. They register under the party list system, B. They do not field candidates in the legislative district's election, where A party that participates in the legislative district elections may still participate in the party list through a sectoral wing. B. A sectoral wing can be part of the political party's coalition, but the former must be registered independently in the party list system. Fourth rule or fourth guideline for party list system under Atong Paglaom is sectoral parties or organizations may either be A. Marginalized or unrepresented, example, labor, peasant, or fisher folks, or B. Lacking in well-defined political constituencies, example, professionals, women, elderly, and youth. Fifth guideline. The nominees of sectoral parties or organizations of either type must A. belong to the representative sectors, and B. have a track record of advocacy for their respective sectors. Majority of the members of a sectoral party of either type must belong to the sector they represent. Sixth rule. National, regional, and sectoral parties or organizations shall not be disqualified if some of their nominees are disqualified, provided they have at least one nominee who remains qualified. Disqualifications and qualifications. RA 7941, an act providing for the election of party list representatives through the party list system and appropriating funds thereof. Who are the disqualified parties? 1. Religious sectors. 2. Foreign organizations. 3. Advocating violence or unlawful means. 4. Receiving support from any foreign government, foreign political party, foundation, organization, whether directly or through any of its members or officers, or indirectly through third parties for partisan election purposes. 5. Violating or failing to comply with laws, rules, or regulations relating to elections. 6. Declaring untruthful statements in its petition. 7. Ceased to exist for at least 1 year. Or 8. Failing to participate in the last 2 preceding elections, or fails to obtain at least 2% of the votes cast under the party list system in the 2 preceding elections for the constituency in which it has registered. Who are the qualified sectors? The qualification applies only to sectoral parties, so dili sa district representative and party list. Participating in national or regional parties need not fall under any of these sectors. 1. Labor. 2. Peasant. 3. Fisherfolk. 4. Urban poor. 5. Indigenous cultural communities. 6. Elderly. 7. Handicap. 8. Women. 9. Youth. 10. Veterans. 11. Overseas workers. 12. Professionals. What are the 4 parameters of the party list system? 1. 20% allocation. 20% of the total number of membership of the House of Representatives is the maximum number of seats available to party list organizations in the House of Representatives, in the Congress as a whole. And then 2% is 2% threshold, where the party list garnering 2% of the total votes cast in the party list elections guarantees a party list organization 1 seat if nakaabot ka sa 2% total votes cast. So, per 2% is 1 seat. 3. Additional seats. The additional seats, that is, the remaining seats after the allocation of the guaranteed seats, shall be distributed to the party list organizations, including those that receive less than 2% of the total votes. If not pinabilin, this distribution will continue until all seats have been filled. And the last one is the 3-seat cap. The 3-seat cap is constitutional. Note, it is intended by the legislature to prevent any party from dominating the party list system. There is no violation in the Constitution because the 1987 Constitution does not require absolute proportionality for the party list system, from the case of Banat versus Comelec 2009. Rules of the computation of seats, 2-round allocation. Step 1. Compute the total number of seats allocated for party list representatives. Step 2. Rank all party list candidates from highest to lowest based on the number of votes they garnered. Step 3. Compute for each party list candidate's percentage of votes garnered in relation to the total number of votes cast for the party list candidates. So, ang ilang total number of votes as per the total allowable maximum population of party list representatives in the House of Representatives. And then 4, round 1, allocate 1 seat each for a party list that garnered at least 2% of the total number of votes. Step 5, round 2, assign additional seats from the balance, that is the total number of party list seats minus round 1 allocations, by 1, allocating 1 seat for every whole integer if a party garners 2.73% of the vote. Assign it 2 more seats. 2 more seats. Ibalik to, nagwa naman siya. Assign it 2 more seats. Nga naman. Kay maximum ang 3. But he is supposed to have 2%. B. Allocating the remaining seats, that is the total seats minus round 1 and round 2A allocations, to those next in rank until all seats are completely distributed. Step 6. Apply the 3-seat gap if necessary, from the case of Banat versus Comelec Supra. In Araro versus Comelec, the Supreme Court further modified the formula used and interpreted the Banat versus Comelec. Thus, the formula to determine the population garnered by the party list group would now henceforth be, ganun na lang ang formula para madali, number of votes of party list over total number of valid votes for party list representative is equal to the proportion or percentage of votes garnered by the party list. The formula to determine the additional seats to be awarded would be total number of party list seats available minus total number of seats allowed in the first round multiplied by proportion or percentage of votes garnered by the party is equal to additional seats awarded.